Welcome to Lawpulse YouTube channel. Please subscribe YouTube Lawpulse channel. Today, let us discuss about the growth of the administrative law. The administrative law is not a law. It is not connected to the constitutional law as such. But what are all the reasons for the growth of the administration law and then how it has been grown? Let us go in detail with regard to this. Let us say the first reason for the growth of administrative law is expansion of government functions. With the rise of the welfare state, the government took on more regulatory and services functions, requiring the specialized bodies to administer the law. Because the legislators who makes the law, they cannot administer the law. That is the main reason for this administration law. And then traditional judicial system also could not handle the volume and complexity of the modern regulations. This is one of the significant reason for the growth of the administrative law. And secondly, the need for the delegated legislation. The delegated legislation, it is nothing but a trial and error method, and it was an experimental method. And always the legislatures cannot spend more time for the welfare and for the administration as such. The legislatures delegated powers to the administrative authorities. For what? That is to make the rules and regulations and orders. So that is the main motto of this administrative law and delegated powers to this. This allowed the flexibility and expertise in the governance rather. The legislature is not expertized in all the subjects, whereas the delegated legislature, that is executives, they were all expertized many subjects. That makes easy for the administration as such. Thirdly, the speedy and efficiency. So the main aim of welfare state is to give the speedy justice and speedy dispensation and speedy solutions to the people of the welfare state. The main object of this democracy, the main object of this law is to see the speedy and efficient redressals and the problems have to be solved. And for this reason, the delegated legislation and the administrative law serves a lot. For example, the formation of the tribunals and the authorities rather, the tribunals gives the quick orders and the relief to the people. And this administrative adjudication provides faster and more informal resolutions to the traditional courts. Suppose if the same thing refers to the courts and all, it is a matter of the delay and it is the matter of time consumption and all. So therefore, the delegated legislation and then the tribunals and the tribunals constituted with the delegated executives and all. So they solves the problem. This is another object of the administrative law. And fourth, rather, the growth of the public corporations and regulatory bodies. Main aim of law is not only to seek the enforcement of the laws, whatever it is, in positive way rather. The laws will be executed, the laws will be enforced through the agencies which are constituted under the delegated authorities like the institutions like SEBI, like TROI and RBI, Reserve Bank of India, etc. These are all emerged in the course of the time after as the law grown, as the law emerged, as the law developed and progressed in the way rather. And fifthly, rise of judicial review and principles of natural justice. Rather, this is very important to say that the courts started developing the principles to control the administrative actions, ensuring the fairness, reasonableness, and protection of the individual rights. The administrative law is only derived from the constitutional law as such. The administrative laws, if at all the administrative laws are said to be are not according to the principles of the natural justice, or if it is not according to the principles of the constitution as such, then the courts will intervene and the courts will, the judicial organizations and judicial courts will make sure, and it keeps the administrative actions in a path rather to ensure the fairness, reasonableness and protection of the individual rights. Of course, always the protection of individual rights, it will be lied and vested with the constitutional courts as such. That means to say the judicial review and the decisions taken by the delegated legislation or the administrative authorities is subjected to the judicial decisions of the courts as such. And sixthly, the global influence and comparative jurisprudence as such. This is the administrative law in India was heavily influenced by the developments of England as well as the United States as such. Even though according to the separation of powers, the executive is different, legislative is different and judiciary is different, but we have adopted this administrative law and administrative system when compared to the principles and compared to the system available either in England or in US rather. Over time, the Indian courts adopted these doctrines to Indians also. So totally we can say these are the important aspects of the reasons for the growth of the administrative law in the course of time.